Excellent. Good morning, everybody. Thank you so much for joining us today. We are delighted to welcome you to the Iowa Coalition for Integration and Employment. I want to just call your attention to what we have on our agenda for today's meeting. And I'm really hoping that you will mark your calendars for next year's meetings. I apologize that we have kind of bounced dates on you. I know we were pretty standard on the third Thursday of the month on the months that we met every quarter. And then as we tried to look at opportunities to go back into in-person meetings, I'm afraid Voc Rehab didn't always have the room available that we needed. Our plan is to continue to offer, if we're able to, hopefully we're able to go back to in-person meetings next year. And we would offer a virtual option as well for all the folks who aren't able to come in person. So, excuse me, if you please look at this slide, the dates for our next coalition meeting is November 17th. It will be virtual. So it'll be 10 to 12:30. And then for next year, we have, we kind of alternate. I spoke to VR this morning and reserved a room. So we're hoping that we're gonna meet in person. And our meetings will be 10 to 3. They'll be in Des Moines at Iowa Voc Rehab Services. We give you, if you're newer to the coalition and you don't remember any meetings in person, it's definitely worth coming. And it's fun. It will be so nice to see all of you. The meetings are between the 3rd and the 4th Thursdays based on the room availability at VR for 2023. So the meetings are February 16th, May 25th, August 24th, and November 16th. Planning on 10 to 3 in person at VR, and then we'll also share virtual connection for folks. Today, I am so excited about what we have in store for you today. We have Bill Stump and Josie Gittler, who are going to talk with us about guardianship and proposed changes to the guardianship rules. We're going to have a federal policy update with Julie Christensen with National ICIE. We're going to have a Medicaid update with our very own Leanne Moskowitz. We're going to have a state policy update, and I know typically we put those, put that with the federal policy. I'm afraid due to our schedule today, Brooke is only able to be on for the first hour of our meeting. So she has very graciously given me talking points to share with you from a DD Council and state policy update. We also will have an ICIE update. There's a lot going on with ICIE right now. And then any other updates that folks have. So I am just going to go ahead and please feel free to share any questions or comments in the chat as we go through the meeting at different times, depending on sort of who's presenting and how it's structured. You're welcome to unmute and ask questions, that kind of thing, or make comments. For our first presentation on guardianship, because there's a lot of content, we're going to ask if you could please just hold your questions until the end, or feel free to go ahead and type them in the chat at the time that you have them. And then at the end, we'll go ahead and ask Bill and Josie, just because I know they want to try to get through all the content and then address questions. So I am going to go ahead and start with introducing Josie and Bill. Josie is the Wiley B. Rutledge Professor of Law at the University of Iowa College of Law. She was the coordinator and reporter for the Iowa Supreme Court Guardianship and Conservatorship Reform Task Force. She's the co-director of the Institute on Guardianship and Conservatorship, which is affiliated with the College of Law. And she's the president of the board of the nonprofit Iowa Guardianship and Conservatorship Association. Bill Stump is one of the most amazing advocates I've ever met. You probably know Bill, who's been just a very committed, very regular coalition member, and he and his son Kyle have done amazing things from an advocacy standpoint in connecting and sharing what's important for them and their family, and for really all Iowans with disabilities. So I am just going to turn this over. If Jess, can you please put in the chat, I put the link to, we have a share folder for folks where all the materials for today are in the share folder. So the presentation that that Josie and Bill are doing is in the share folder. You just have to get to it. And so you can access that as well while we're doing this. Look at me do technology. All right, can everybody see that? Excellent. Okay, I am going to turn it over to Josie and Bill. Tell us about guardianships and conservatorships.
Could you go to the next slide, please, Amy? Bill, Bill, you start.
Yes, the Iowa Guardianship and Conservator Association, which I am also a member of, so just to point that out with Josie, advocates for needed care for protected persons under guardianships and conservatorships, and advocates for the interests of guardians and conservators who are responsible for their care and protection. So we have a website, and that address is listed on the bottom of the slide.
Next, I'm now going to hopefully provide you with informative background about the Iowa Guardianship and Conservatorship system. Next. Next.
I muted myself and it wasn't letting me change.
Oh, okay.
I mean, come on, you wild slide. There we go. Is that right?
Okay. Thank you, Amy. So all adults are assumed to be legally competent to make their own decisions, good decisions, bad decisions, or indifferent decisions. One of the privileges of being adults is you can decide for yourself whatever you want. However, the Iowa Code, like statutes in all states, does authorize a court to appoint a guardian as a substitute decision maker for an adult who lacks decision-making capacity and is unable to manage his or her personal affairs, like their health care, like their living arrangements. It also authorizes the court to appoint a conservator as a substitute decision maker for an adult who lacks decision-making capacity and is unable to manage his or her financial affairs. Our focus is going to be on adults with respect to the guardianship and conservatorship system, but a court may also appoint a guardian and or a conservator for a minor who meets certain criteria. And if you have questions about that, then will be happy to answer them at the end of our presentation. Next. As you can see from this slide, there are nearly 23,000 pending open cases, guardianship and conservatorship cases at the end of fiscal year 2021. That is a large number. Nearly 23,000 people in this state are under guardianship and conservatorship. And I might add that the number of guardianships and conservatorships in this state compared to our total population, we have more cases in that regard than many other states. Next. So in 2015, 2016, I and my research assistants at the University of Iowa College of Law, with some funding that had been appropriated by the Iowa legislature, did a study involving a review of over 4,000 guardianship and conservatorship case files, because there was very little known about what was actually occurring in Iowa's guardianship and conservatorship system. And as you, I hope, can see, but maybe it's difficult because the figures are small, the majority of adults under guardianship and conservatorship are those with intellectual disabilities. In my study, examining 4,000 case files, it was 62%. There also are adults with Alzheimer's and dementia, adults with mental illnesses, adults with brain injuries, as well as other kinds of conditions. Next. That study revealed that there were major problems with the guardianship and conservatorship system, and raised a concern about whether persons under guardianship and conservatorship who were highly vulnerable were receiving needed care and protection. And so in 2015, Chief Justice Katie of the Iowa Supreme Court established an Iowa Guardianship and Conservatorship Reform Task Force. Next. It had 70 members. It was very large. It had 70 members from throughout Iowa, and they represented all of the major stakeholders in the system, including advocates for and providers of services to individuals with disabilities and their families. And as Amy mentioned, I was the coordinator and reporter. In other words, I did the staff work for the task force. Next. After 2.5 years of work, the task force submitted its final report to the Iowa Supreme Court. And you see here a picture of the cover of its report, and you see here a link for those of you that would like to view the report and read about its efforts and its recommendations. There were 272 recommendations. 272. I think that the number of recommendations reflected the fact that the task force found that there were multiple and serious problems with the system that needed to be addressed, problems of a systemic nature. And some of the recommendations were legislative in nature. Next. In response to the task force report and its legislative recommendations, House File 610, which governed adult guardianships and adult conservatorships and minor conservatorships, amended Chapter 633 of the Iowa Code, which is known as the Probate Code. It also created a new chapter of the Juvenile Code 232D, which gave the juvenile court for the first time jurisdiction over minor guardianships. I want to emphasize that it passed, House File 610 passed both the House and the Senate unanimously on a bipartisan basis, which is unusual in recent years to have any legislation enacted unanimously on a bipartisan basis. and it was signed into law in May of 2019 by the governor, who singled it out for a public signing. It had a delayed effective date of January 1st, 2020, and it incorporated and reflected the task force legislative recommendations. In the interest of full disclosure, I was the original drafter of what became House File 610 that was enacted. I've emphasized that it passed the House and Senate unanimously and a bipartisan basis. I will note that the only opposition to it was the probate section of the Iowa State Bar Association, who had their own bill, which did not incorporate and reflect the task force recommendations and which basically didn't go anywhere. Okay, next. So now I'm going to give you an overview of what I will call the statutory framework for legal framework for the guardianship and conservatorship system. Next. So not everybody who has diminished decision-making capacity can have legally appointed a guardian or conservator. The Iowa Code provides that for the court to appoint a guardian for an adult, it has to find by clear and convincing evidence. That's the amount of evidence that there has to be, that the decision-making capacity of the respondent, the person for whom a guardianship is sought, is so impaired that the respondent is unable to care for the respondent's safety or to provide for necessities such as food, shelter, clothing, or medical care, without which physical injury or illness may occur. So there has to be diminished decision-making capacity, and there have to be limitations as a result of diminished decision-making capacity on the ability of an adult to provide care and protection for herself or himself. And the appointment of the guardian must be in the best interest of the respondent. Next. Standards for appointment of a conservator. The Iowa Code says the following. Remember, a guardian is a substitute decision maker who makes decisions for an adult having to do with their personal living arrangements and with health care and the like. A conservator is a substitute decision maker for an adult who is unable to manage their financial affairs. So the Iowa Code says that the court may appoint a conservator for an adult if it finds, again, there must be clear and convincing evidence that the decision-making capacity of the respondent is so impaired that the respondent is unable to make, communicate, or carry out important decisions concerning the respondent's financial affairs. So again, there must be diminished capacity, plus, as a result of the diminished capacity, an inability of the adult to manage their financial affairs. And again, the appointment of a conservator must be in the best interest of the respondent. Next.
This is Judy.
Okay.
So before a guardianship or conservatorship is established, I do want to emphasize that the statute says the consideration should be given to possible less restricted alternatives. And even if a guardianship or conservatorship is appropriate in light of the statutory standards or criteria that I've just read you, a limited guardianship or conservatorship should be considered rather than a full guardianship or conservatorship. In other words, let's assume that there is a person, an adult, with diminished decision-making capacity. It does not mean that a guardianship or a conservatorship is always going to be necessary or desirable. And so consideration should be given to what might be possible, less restricted alternatives, and consideration should be given to a limited guardianship or conservatorship as opposed to a full guardianship or conservatorship. Next. Here are some possible alternatives to a full guardianship, which I'm not going to go over since you have this presentation available to you. You can review some of those alternatives that are listed. Next. Here are some possible alternatives to a full conservatorship, which again, you can look at the presentation that is available to you now and in the future and review. Next, I do want to single out one increasingly popular alternative to guardianship or a conservatorship.
Wells, extension 200.
And that is supported decision-making. And I assume, but perhaps I should not, I'm just going to say, you know, I think all of us who are either part of the disability community or work with individuals within the disability community, I hope are familiar with supported decision-making, which I have defined in this slide as an option where people with disability use trusted friends, family members, and professionals to help them understand the situation and choices they face so they can make their own decisions. Next. The Chapter 633 of the Probate Code, as amended by the 2019 Guardianship and Conservatorship Reform legislation, sets forth detailed requirements for guardianship or conservatorship proceedings, and they include requirements regarding the contents of a petition that initiates a guardianship or conservatorship proceeding that asks the court to appoint a guardian or conservator. I do want to emphasize that even before the 2019 reform legislation and after the 2019 reform legislation, a respondent, that is to say a person for whom a guardianship or conservatorship, the appointment of a guardian or conservatorship is requested in a petition, is entitled to be represented by counsel, by an attorney. There is a hearing requirement. There is a requirement for a background check of a prospective guardian or conservator. Let me just stop here for a minute and say, prior, for example, to the 2019 reform legislation, there was background checks were required for a whole slew of people, even a school bus driver. But there was no requirement of a background check of a prospective guardian or conservator, despite the power that they have once they're appointed. So one of the reforms was to require a background check of a prospective guardian or conservator. There's also a requirement of a bond or an alternative to a bond for conservators. Next. Now, what I just talked to you about is the front end, so to speak, of the guardianship and conservatorship system. That is, what are the standards, what are the criteria for court appointment of a guardian or conservator, and what are the proceedings that a court has to go through in order for a judge to make a decision whether to appoint or not appoint a guardian or conservator. Now I want to talk about the back end of the system. That is to say, I want to talk about what occurs once a guardian or conservator is appointed once a guardianship or a conservatorship is established. Next. So Iowa courts have an ongoing responsibility to monitor guardianships and conservatorships. And the goal is to ensure the well-being and protection of the highly vulnerable persons subject to guardianship, the protection of the property of persons subject to conservatorship, and the accountability of those who are appointed to serve as guardians and conservators. One of the major findings of the task force was that court monitoring of guardianships and conservatorships all too often was ineffective and inefficient. And as a result, persons under guardianship all too often were not receiving needed care and protection. So this court monitoring function, I cannot overemphasize, is really important because adults under guardianship and conservatorship, who the code, Iowa code says are protected persons, calls protected persons. One of the things the reform legislation did was, used to be prior to 2019, that the Iowa code referred to these persons under guardianship and conservatorship as wards. The reform legislation said, no, now they're not to be called wards any longer. We're going to call them protected persons. So the court monitoring function is of great importance because protected persons they're vulnerable and they're in need of protection. Next. So we have, and I'm using a rhetorical we, let me say, there is data and evidence that protected persons are very vulnerable to abuse and neglect and financial exploitation. And in this slide, you see some of the studies about abuse and neglect of adults with intellectual disabilities, which, as I have said, constitute this largest category of protected persons under guardianship and conservatorship. And again, I'm not going to go through, read you what's on the slide, but I direct your attention to it. We have a serious problem, I think, with abuse, neglect, and financial exploitation of persons with intellectual disabilities. Next. And unfortunately, sometimes guardians and sometimes conservators abuse, neglect, and financially exploit those for whom they are responsible, for whom they're supposed to be providing a needed care and protection. I cannot give you precise data on numbers, but I think there is a consensus among those who have studied this that there is, again, a very real problem of guardianship and conservatorship abuse. Next. So I'm just going to give you one example of guardianship abuse. And actually, this is an example of guardianship and conservatorship abuse. And as the slide indicates, a mother and a daughter were appointed as the guardian and conservator of a relative with intellectual disabilities. And they abused him and they stole more than $50,000 from him. And the neighbors reported to DHS that this mother and daughter, this aunt and niece, only checked on this middle-aged man with disabilities about once a month, and they rarely gave him more than $10 at a time, and that his neighbors had to bring him food because he always ran out of of food. Now, this was pre-2019, the reform legislation, but I want to particularly underline two things. There was no background check of the aunt and the niece who were appointed guardian conservator. And I want to point out that something was ineffective about court monitoring because the court didn't recognize, didn't identify that this individual under guardianship and conservatorship was not receiving care and protection. It was his neighbors that reported his case to DHS as dependent adult abuse that led to this being discovered. Next. Here are some examples of conservatorship abuse. A conservator routinely used money of the protected person for personal gambling expense. Now, a conservator can make decisions with respect to financial affairs of a protected person, but it has to, conservator should do so for the benefit only of the protected person, not for his or her own benefit. And here we have a conservator that was using money to pay off his gambling expenses. Another example is the conservatorship that was using the protected person's money for bowling fees. We have a conservator who was using the protected person's money for new cars for himself, despite the fact that there was already a van with a handicap rack for transporting the protected person. Next. So one of the major changes of the 2019 reform legislation had to do with reporting requirements of guardians and conservators. The reform legislation, under the reform legislation, the Iowa Code for the very first time required that upon appointment, a guardian or conservator had to submit an initial plan. The guardian had to submit an initial care plan, and the conservator has to submit an initial financial management plan. And the purpose of these plans, this was consistent, by the way, this requirement was consistent with a really major recommendation of the task force. And the purpose of this requirement for submitting initial plans was to encourage a newly appointed guardian or conservator to sit down and think through, what are the needs of my protected person going to be? And what kinds of resources and services might my protected person have to meet those needs, and then to develop a plan that could meet those needs. And then the related but distinct purpose was to, after that plan was presented to the court allowed the court to make a determination at a very early stage whether there was going to be an appropriate plan in place to ensure that the protected person received needed care and protection. And most importantly, to prevent problems before they occurred rather and had negative consequences. Because before 2019, the only reporting that a guardian and conservator had to do was to submit annual plans to the court. So the court was in effect put in the position of what I as a lawyer would call ratification of whatever had occurred. And if there were problems, the court was all too often not able to correct things that had occurred that were inappropriate. The other major change that I want to underline that the code made was to say these reporting requirements of an initial plan and of an annual report, they can't be waived, and they have to be done annually. The plan has to be submitted after appointment within 60 days, and then thereafter there has to be an annual report submitted by a guardian or conservator to the court. And prior to 2019, there were many guardians and conservators who had an annual reporting requirement that had been waived and were only required to submit a 5-year or a 3-year report. Next. So, reporting forms for use by guardians and conservators. The task force found that the forms being used, this is prior again to 2019, by guardians and conservators to satisfy their reporting requirements were not providing adequate guidance to them because they lacked specificity. They didn't tell guardians and conservators with any degree of specificity what they needed to put into the form that they were going to submit to the court. And the task force found that the forms that were in use prior to 2019 were not generating the information needed by judges to effectively and efficiently to carry out their monitoring responsibilities. So after the enactment of the 2019 reform legislation, the Iowa Supreme Court issued new reporting reforms for guardians and conservators, setting forth a specific information, if applicable, and I underline if applicable, that the guardian was to include in her or his initial plan and subsequent annual reports, and that the conservator was to include in his or her initial financial management plan and subsequent annual reports. Next. These Supreme Court forms have to be used by pro se guardians and conservators. Pro se guardians and conservators are guardians and conservators who are not represented by counsel, who are not represented by an attorney. And I want to emphasize that it is not required that a guardian or conservator have an attorney to fill out the forms and submit them to the court. And the majority of guardians and conservators, in fact, prepare and submit the required forms without the assistance of an attorney. And for those of you that are not guardians and conservators who have not been doing reporting to the court but would like to look at the Supreme Court forms, they are available in a fillable PDF format on the Iowa Guardianship and Conservatorship Association website when you have the link to that. Now, I've gone on at great length, and I'm now going to turn it over to Bill with this preface. When the reform legislation went into effect, January 1st in 2021, there was a big transition that had to take place from the old way of doing things under the broken system to the new way of doing things under the new law. And so there was a lot of confusion and there was some pushback particularly from existing guardians and conservators, because they were not used to doing, they did not even understand necessarily what they had to do under the new law. So now I'm going to turn it over to Bill, who can just give you a little overview of his experience as a guardian with the new law and the Supreme Court forms. Next.
Thank you, Josie. And I think that set up sort of the legal end of things. I really want to give you what my perspective is, having been a guardian, and I am co-guardian with my daughter, Kara, who's actually on this call as well. So, and I think many of you know her. So really the information on the report is the kind of information that is really needed by the court to make sure guardians and conservators are accountable for how they carry out their responsibilities. And I kind of related, I worked as a nurse, I'm retired. We did care planning, and it's talking about how you're gonna take care of that patient and prepare them for discharge. This is no different. It's what you're gonna do in the future. And for those that are in education, it's not unlike an IEP as well. I mean, you're laying out a process for the year. And parents and guardians, and I want to emphasize that, are really the people that would provide this information. And if you look at the form, you'll see that. So it's not an attorney, it's the parent or guardian that will do that. And under the old law in 2019, just basically had to do the same information every 3 years. And as Josie had pointed out, it was basically after the fact. And it was 1 page. I usually have either 1 page or 1.5. I just ditto everything I did the last year because it was easy to do. But if somebody's abusing, doesn't lay out anything for them to be held accountable for. I do use the Supreme Court forms. Don't find them particularly onerous to fill out. And the big news is we don't have to pay for an attorney to do that. And attorneys, as we all know, can be very expensive with guardianship conservatorship. One of my worries is that what would happen when I'm gone and somebody else may be appointed to be my son's guardian, and how will they be accountable to the court? And I'll use an example as Kyle works in competitive integrated employment. So makes money and he's got an ABLE account and now has a special needs account or trust as well. And the point with that is that guardians and conservators should understand these programs, including Social Security disability, and how all that works. The Supreme Court form lays that out almost like a living document. So it's not surprising to me, to be honest, because I remember going back to the beginning that some guardians and conservators were confused. I was confused, and many were upset by the requirements of the law. But with education, and I'll emphasize that, most have come to understand it and accept it as necessary to protect persons with disabilities like my son. So that's my take on it. So thank you.
And so Bill and I, can you show the next slide, please? Bill and I would like to present the following to you. Remember, I told you that the only opposition to the 2019 reform legislation was from some lawyers, what I would characterize as relatively small group of lawyers in the leadership of the probate section of the ICIE. And unfortunately, there has been a continuing effort on their part to amend the 2019 reform legislation to what I would submit to you as an attempt to turn the clock back to the broken 2019 system with less reporting, with less court monitoring, and therefore less protection, less guidance to guardians and conservators, and less protection for those under guardianship and conservatorship. So Bill and I are here today under the auspices of the nonprofit Iowa Guardianship and Conservatorship Association, and it's anticipated that an amendment to the 2019 reform legislation will be introduced in the Senate during the last legislative session, which our nonprofit will support, and we know that other organizations, individuals will support, and we hope that lots of other organizations and individuals will support. And it will do two things. It will promote greater education and greater support of guardians and conservators, particularly pro se family members who make up the almost vast majority of guardians and conservators. It will promote greater education and support of guardians and conservators by the judicial branch in accordance with the recommendations of the task force, which as of today's date have yet to be implemented. And the other thing that it would do is that it would spell out with greater specificity the items, if applicable, related to a protected person's finances that the conservator should include in the initial financial management plan and the subsequent annual reports. And the purpose would be to provide better guidance to conservators regarding the reporting requirements and to prevent and remedy actual and potential financial exploitation of protected persons. And I think that second purpose, I think that second thing that the amendment would do is of particular salience to you all because of your focus on employment of persons with disabilities. And if they are employed, they were going to have income. And then the question arises, do they or do they not need a conservator? And if they do need a conservator, then what is it that the person, probably a family member, has as guidance, needs to have as education and support as to how to fulfill their responsibilities, and what the court needs to make sure that that person, protected person who has income as a result of employment, or, you know, maybe SSI, or maybe they have inherited money, or maybe they have an insurance settlement. You want to make sure that that person is not financially exploited. So we're at the end, and we'll take questions for myself.
And I'd just like to throw in there that it's pretty obvious that I support this and have found it in doing the annual report. It was really easy because of the care plan, and it was just to basically, if you didn't accomplish something that you talked about, why not? So I just want to throw it out there. Your support would be very appreciated. Thank you.
So Jeff, Amy, how do you want us to proceed now? Do you want to just read off the questions in the chat room? And
Sure. And I just want to, I know we have folks who are kind of coming in and out. So we'll repost the link to the presentation materials in case folks didn't get that. And then I'm gonna stop sharing, but I want to call attention to the fact that on the last slide is Bill and Josie's contact information. All right, so folks, I'm gonna go ahead and put the share link again in the chat for folks who might not have gotten that with the materials for today. And then Mari shares, it was surprising to me that judges have the responsibility of monitoring and understanding options for supported decision making. Mari, do you want to add anything to that, or any additional comments or questions with that, or primarily just kind of wanted to share your surprise around that?
Yeah, nothing specific. I just think that that's a lot for judges to have responsibility for, you know, to monitor those situations and be aware of all the options and things like that. I just wonder what education they get around that, and or support to make sure that things like that happen. Seems like a lot.
Can I respond, Marty? That's a very insightful and important question. The statute, the Iowa code says that they should consider before appointing a guardian conservator less restrictive alternatives, but they do not have the knowledge and experience about less restrictive alternatives, including supportive decision making. So what happens as a practical matter is they kind of rely on the lawyers or the petitioners to have considered whether they're less restricted alternatives and inform them. And it's not a requirement that is being implemented the way it should be. And I think we have like a lot of education to do about, you know, there are less restricted alternatives to family members, others who might be seeking a guardianship or otherwise be seeking a guardianship or conservatorship, especially as to minors as they reach the age of majority, because as you know, once they reach the age of majority, their parents can no longer make decisions for them. And so that's kind of a crucial point. And I think then everybody that's sort of involved with a family at that point needs to be aware that they shouldn't automatically think that a guardianship or conservatorship is called for, and what are the less restricted alternatives that should be considered. And if they decide that a guardianship or conservatorship is called for, they should tell the court, here's what we've considered. And for whatever reason, we think they're not going to be appropriate. And so that's why we're coming to you, Judge, to asking you to appoint a guardian or conservator. Mari, is that a sufficient response to your?
Yes, thank you.
Thank you. Susie, do you want to just go ahead and share your comments and thoughts?
Sure, I can do that. You know, I agree with you that the annual paperwork is much simpler than what parents think it is. They get very, when they see how many pages it is, they get pretty upset about that until they start to look and there's like one question per page. But the other thing, that we have a parent group that meets every month, and some of the frustrations that I hear from the parents are that lawyers are telling them to do a power of attorney. And it's like they're saying that you can do a power of attorney, but their adult child, really isn't competent to be able to sign a power of attorney. And some of them have felt frustration in the fact that the lawyers, you know, charge so much money. There isn't any alternative for them to pay for it. I've had parents tell me they've spent over $2,000 for guardianship, simple guardianship, uncontested. And I think that's kind of crazy. So my question is can an individual, I mean, I've seen all the paperwork on there. Is it possible for somebody to go in and do it without an attorney? I mean, I understand that the protected person would need an attorney representing them, but do you feel like an individual person could go in and do it themselves?
So this is another very excellent observation and question, and I'd like to separate it into two different responses, Susie, or two. One is the issue of a power of attorney rather than a guardianship or a conservatorship. A power of attorney, I think, oftentimes may be a necessary or maybe a good alternative to a guardianship or conservatorship, because it doesn't, unlike a guardianship or conservatorship, a power of attorney doesn't take away all the autonomy and rights of a person, and the person himself or herself gets to select who they want to make decisions for them. So we have to, I mean, and I know this group is probably has knowledge and experience beyond what lawyers, my profession, generally have, that an individual with an intellectual disability, there's a continuum, right, of the degree of cognitive impairment, from, you know, minimal to severe, profound. And so it is quite possible, but I don't want to say that it always occurs. I just want to say there's a possibility that an individual with some degree of cognitive impairment still will have the requisite decision-making capacity to sign a power of attorney. That's issue one. And I can't comment, you know, it's a case-by-case decision. Now, as to your second question, if a power of attorney is not an appropriate alternative to a guardianship or conservatorship, can a person seeking the appointment of a guardian or a conservator file a petition on their own without an attorney? And I would say it depends. It's a case-by-case determination. If it's you used the words that were crucial to me. You said a guardianship and you said uncontested, right?
Yeah.
And if a family member is seeking a guardianship and it's a simple guardianship and it's uncontested and it's clear, there's evidence. Remember, there has to be clear and convincing evidence that the individual for whom a guardianship is sought meets the standards that I read out to you, then the family member can file a petition. They don't need to have an attorney. There's no requirement of an attorney. Now, I would say if the evidence is not, you know, on its face clear and convincing, and or it's going to be a contested case. That is to say, the person for whom the guardian is sought is objecting, then, you know, an attorney may be called for. And I just can't tell you any more than that. It's not, you know, always yes or always no. It depends. It's a case by case determination. But what I want to say to you is that in every case in which a family member decides to seek a guardianship, an attorney should not be required. But that doesn't mean that in a particular case, an attorney should not be called for. I think conservatorship is more complicated because, again, it's a case by case determination of whether the family member seeking conservatorship can file a petition on his or her own. It depends, you know, what kind of assets, what kind of income, what kind of property does the person for whom a conservatorship is sought have? Is the evidence clear and convincing, or, you know, is it going to be more complicated? So could I just give you an example? If the only income of John or Jenny, who is 20, is SSI, then I don't know that a conservator is necessary. The parent might just apply to be the representative payee and shouldn't have to go through all of what they would have to go through to have a conservator, be appointed a conservator, and pay for an attorney, and then for years do reporting, right? Now, if John or Jenny, who's 20, has a job and has, you know, is worth minimum wage, but they also maybe have a legal settlement of $100,000 from, or they've inherited, you know, $100,000 or more, you know, or the grandparent is owner operator of valuable farm property, and the John or Jenny is going to be the beneficiary of their will or trust, then yes, you probably need a conservator appointed, and you probably need an attorney to help. Does that answer your questions? I can't give you a yes or no answer.
Yeah, I know, and I appreciate that. And that's kind of what I was thinking, you know, that the answer is it's always well, it depends. But I do appreciate that. And the parents are just that maybe have financial issues and are not able to pay for it, and maybe aren't even able to understand how to do it themselves. There is no other alternative for them. Used to be that you could go to legal aid and they would assist with that, but I've not found any other ways for people. They won't even do it. And so families are kind of left with not going through the process. And I think that can be kind of dangerous for those.
Yes, and Susie, that's why the association is supporting this amendment to provide more education and support to both prospective and actual guardians and conservators. And there were some recommendations in the task force which just have not been acted upon.
Yeah, that would be really good.
And I think we really need that. I mean,
I do too. Yeah. I mean, the parents are really needing that. And I did send a document that I created. I mean, I have a daughter with a significant disability that I'm guardianship for too. And, you know, every year I'd go in there since the new changes to do the annual paperwork, and I couldn't remember where I was at, what I was doing, and where I needed to go and all that stuff. And so the last time I did it, I created a screenshot cheat sheet of how to actually go through it. And I sent it out to all the parents in our group, and I've sent it to Amy and Jess so that, or maybe just Jess, so that they can also send that out.
Could you
to everybody.
That to Bill and me too, and we can maybe post that
Oh, sure, absolutely.
On our website. And there is a petition form on our website.
Okay, great.
And we can share it with the coalition as well.
Yeah, and just to give a plug for our Thursday night, once a month, I think it's the second Thursday of the month, we have a parent gathering, and parents can show up when they have questions related to guardianship or SSI, applying for benefits, Medicaid, the waivers, and services at vocational rehabilitation. And we kind of just start with a poll, and they decide what topic they need to talk about, because you need the information when you need it. And so that's where we start. And Jennifer Donovan, I don't know if you are familiar with Jennifer Donovan at the Iowa Division on Aging. She's with the Office of Public Guardianship. She always shows up. I think there's only been one time in the last 2 years that Jennifer has not been there. And so she's able to give that legal, she's a lawyer. She's able to give that legal advice that, I might try to give, but might not actually be accurate, which I try to not do, because that wouldn't be right. Anyway,
Susie,
yes, Bill,
are you
yes.
the contact person for that parent group, and is that something that's held at Voc Rehab?
Yes, it's a Zoom that I do. Yeah. You want me to send you that flyer?
Yes, absolutely.
Okay. All right.
Thank you.
You're welcome. Thank you so much for the whole thing. It's very good. And I hope that amendment passes.
Well, I think we're at the end of our time, are we not, Amy? And I appreciate.
We can go ahead and address the other questions that folks have, if that still works for you, Josie and Bill.
Yes, of course.
Gayla, I know that you have a comment next. Do you want to share that?
Sure. Josie, and Bill, thanks for presenting this. I have a question that I think is probably on many providers' minds, and that is, a person comes in with a guardian, and that guardian's reach appears to be larger than it should be. I'm going back to a guardian, we should try less restrictive alternatives, which was kind of the tenet that this is all based on, that we're not overreaching. But when we have guardians come in who say, I don't want my adult child to go on particular outings because he acted up before, and things like that. How do you handle that? How do you handle when a person's basic rights are being restricted and there's no foundation to support that? What should providers do? What kind of advocacy can they do?
You want me to try and answer that, Bill? You want to try and answer that? That is a terrific question. And I was talking to Amy last night, and I said I thought that one of the problems that the law couldn't do anything about was persons, once they're appointed guardians and conservators, try to exercise undue control over the protected person, and don't really consult with, don't take into consideration their preferences, don't do what they can do to encourage as much as possible their independence. And that's not something that the law, that the Iowa code can really be addresses. Let me tell you what legally can be done if it's severe enough, which is not your example. I don't think would be severe enough, but if it's severe enough, then if a guardian or a conservator is doing things that that maybe they should not be doing, the court should be available for a letter saying, we'd like you to look at what's going on here and consider the removal of the existing guardian or conservator and the appointment of a successor. Now, I can tell you the court won't intervene, I don't, by and large, unless what the guardian conservator is doing is really objectionable. But I was just talking to a person at Disability Rights Iowa, who I know has had several cases where what he has done is he's petitioned the court for removal of a guardian and the appointment of a successor guardian. Amy, that's the cat case I was telling you about. I told Amy about a case where a gentleman with intellectual disabilities had a cat who was his best friend, and his guardian, who was a relative, was allergic to cats and asked the person in charge of the facility where the gentleman was living to get rid of the cat. And that was done without the knowledge, much less the consent of the gentleman, who was devastated. And fortunately, the gentleman had a Medicaid case manager who was distressed by what was happening to him. And Disability Rights Iowa took the case, and they did bring about the removal of that guardian and the appointment of a successor guardian. But now I'm going to put on my, my legal academic hat and say, Gayla, that I don't have your knowledge and experience and your skills as how to diplomatically, as a provider, work with a guardian or with a conservator, a parent that is trying to control more than they should. And so that's where I'm going to stop.
Well, thank you.
Not very helpful, is it, Gayla?
It happens so often, and maybe the answer, as we talk about people creating a plan to be a guardian or a conservator, that there possibly should be a training required for those persons who are going to accept that role, to understand a person's rights and really how you would apply the measure of compelling evidence that whatever restriction is being placed really would be putting the person in jeopardy. I think that people come in with the idea that guardianships are all that in a bag of chips, and the bag has a bottom of what it is they really can do. But I don't think that many are always aware of that. So maybe that's the next phase of how do we.
Gayla, that's so excellent. I'm interrupting you, but the National Guardianship Association has standards for guardians and conservators, and the task force recommended that those standards be adhered to by guardians and conservators, and they are beyond the legal standards that I've talked to, the legal responsibilities. There's what's the appropriate role.
Mhm.
And the focus of these standards is that the guardian should consistently involve the protected person to the extent possible in decision making. And when the protected person is not able to engage in decision making, the guardian and conservator should make decisions based on what he or she understands the preferences of the protected person are or would be, and that the guardian or conservator should do as much as possible to enhance the autonomy and independence
Right.
of the protected person. And so you're right, that's that's not a legal responsibility, but that has to do with what's the appropriate role. And we aren't helping guardians or conservators in any systematic way to understand that.
Thank you. That'll be our next hill.
Paige, do you want to share your comment and question with Josie and Bill, or would you like me to read it?
She might have stepped away for a second, so.
All right.
Sorry. Oh, there she
Oh,
is.
no worries. No worries.
Sorry,
Sorry.
we have so much storm damage. I have all these people coming to do estimates because we're a mess over here after that hailstorm. So my question was about whether there's any like face-to-face interaction with the through that court monitoring process, or if it's just paperwork, or if they like have some, physical presence or like interaction with people in addition to that.
Could I back it? Gayla, I should have let Bill answer your question, because I know Bill with Kyle has done exactly what a guardian should do.
Yeah, I think the only thing I'd add is, and you mentioned education, it's just, and I think that's what this group does so well, is educate folks on various topics. And I think we need to do more, you know, regarding that. And I like your point about families as well as the court system, you know, because I've learned most of what I've learned from other families, really, whether it was education or Medicaid, you know, lots from a lot of other people, including a lot of people that are in this room right now. But I find it real helpful to talk to somebody that's been through it. It puts it in plain language for me, and I need that. I don't know if that helps, but yeah.
It does. It gives us another avenue to consider on how are we going to support people in gaining that insight.
Exactly. And just one comment that I guess this jumps to pages maybe. That's the beauty, in my opinion, of the initial care plan, because you're setting forth what you're going to do. Okay. And there were a couple items, I think, on ours this year that it didn't get accomplished. Something for, I don't even recall the exact thing, but you explain and then on there, okay, last year you said you were going to do this, but you didn't. Why didn't you do it? So there's place to do that. And, you know, there's not really an intervening interval between the year, but my point that I made, and I made it in a testimony, was this lays out that living document. And if a neighbor notices something or they think something's out of whack, they can look at that care plan. And if that guardian is not doing what they said they were going to do, they have that in writing. The old way, there was nothing. You know, absolutely nothing.
And so in answer to you, Paige, two-part, I saw kind of two questions, perhaps. And Bill's just alluding to this. The Supreme Court forms and what we would like the statute, the probate code, the Iowa code, is to be as specific as possible as to what a guardian conservator needs to report that they are doing. And there's specific questions on the Supreme Court form as to whether the guardian conservator, what kind of interaction they're planning, and what kind of interaction they've actually had at the end of the year with the protected person, and what arrangements or provisions are being made for interaction between the protected person and significant others. And that's very important to have that be reported to the court. And then, you know, that's one of the factors the court looks at in deciding whether to approve a report or not. And if it does not, it can always not, the judge may not approve a report, or the judge may have enough questions about the report that the judge can do what's called a show cause order. And essentially say to the guardian or conservator, you need to come in and talk to me about what you're doing or not doing and why. Now, having said that, remember I told you there are 23,000 people under guardianship and conservatorship. And remember that guardianships and conservatorships are only one part of the caseload of a judge. So in Polk County, there is a full-time probate judge, and the total caseload is 5,000 cases. That is a state's trust, and 1,000 of the 5,000 cases are guardianships and conservatorships. And that's just probate court. That's not criminal court. That's not family court. That's not juvenile court. That's not civil cases. So the realistic, there's the potential for a court to exercise oversight now after the reform legislation that didn't exist prior to 2019. But I'm here to tell you, honestly, that, you know, we have limited judicial resources, limited number of judges who have big caseloads, And so does the kind of optimal monitoring that I'm sure all of us would like to see occur always? No. Does it never occur? No, it doesn't never occur. But just, you know, we just have to be realistic about what it's possible for judges to do. And I am convinced that conscientious judges, they are telling me, I've just done a survey of judges, that they are now getting more information than they used to get, and that they're finding it helpful in exercising their monitoring responsibilities. But I'm not, you know, I know that what I would like to see happen is not happening in terms of the kind of monitoring that is optimal.
Thank you, Josie. I'm going to run through the last few comments. Kari says, thanks for the presentation. It's helpful, and the legislation proposed makes sense. So I just want to really encourage everybody. It's so easy to kind of sit back and hear this today and say, yeah, that really does make sense. I'm sure the right thing will happen. But I think we can't take that for granted. So if you have any feeling about this, I strongly encourage you to take action and let those feelings known. I'm going to go ahead and move through a couple others. Susie, Maria Walker suggested that you share the flyer with your group with everyone. And I know that Jess is also putting things in our share folder today. So if you send that to us, we'll throw it in the share folder and we'll make sure it goes out with the notes for your parent group, as well as your screenshot to support it.
I sent that to her, and I also sent her a listing of one of the times when we had a lot of people and a lot of questions. And so I recorded Jennifer's answer to each question and I turned them all into YouTube. So it's like you click on the question and you get the answer from a lawyer. I sent that to Jess too. It's really helpful.
Oh, excellent. Thank you so much. Kara, do you want to share your comments? Or Kara, I'm sorry. I said Kara. Kara, sorry.
Yeah, I was like, is that me? Yeah, so
I know, so sorry.
in regards to Gala, as a provider standpoint, we do see a lot of guardians try to push some restrictions on individuals because they feel that that's not appropriate. Provider wise, we go through a lot of training on what the least restrictive environment would be, or why are we putting this restriction in place. But I really would like also, in addition to the families and guardians, to kind of go through some stuff. I think the case managers also need to be aware of this, because oftentimes the case manager goes, yeah, we'll put in a consent for this individual can't have more than 3 bags of Skittles a day, when medically they're fine, their diet's fine, you know, like just because the family doesn't want it. So we as a provider kind of educate both the family and the case manager too. So there is definitely some work to be done on that end too.
Yep. Agreed.
Thank you. We're gonna have to move on soon, but I also just want to call people's attention to Courtney, who leads Iowa's training and technical assistance for providers on all things Medicaid. Is that fair, Courtney? She's trying to work with Disability Rights Iowa for training, maybe some kind of infographic or handout that would help with providers and guardians to understand the individual rights and what would be considered a restriction to those rights. And she shares, I am sensing that this should cover least restrictive interventions as well, or alternative options. Thank you, Courtney. And then just kind of also confers with also offering training and support to providers, case managers on having crucial conversations like this, supporting families and others, supports to practice supportive decision-making and self-determination, even if a guardianship or POA is in place, giving providers and case managers permission and tools to have those difficult conversations and gently push back. I wanted to just also add, and I'm afraid we don't have a lot of time today, but I know that we have a number of individuals here today who also support youth. And that's a really important conversation as well. It's what is needed for information and for our individuals who interface with youth and their families around some of these issues and how to kind of providing enough information to help them in preparation of what might come next. So that might be something that if people have an interest, maybe we can work with Josie and Bill and put some information together that we can share with those of you that are also working with youth, if that seems like that would be helpful.
Amy, this is Kirsten. I'm just going to jump in real quick. We do have some resources on supported decision-making and kind of approaching it from a least restrictive kind of approach on the Iowa Secondary Transition Learning Community page. And I did take a peek while Josie and Bill were presenting, and we don't have a link to their website on there. So I added that to my notes to add that in.
Kristen, could I just ask you, do you have on that, there is a really good national website on supported decision-making with multiple resources.
Okay.
I can send it to Amy.
You
I
can
can
put
send
it in
you
the,
and-
send it to Amy or Jess, or put it in the chat for everyone, whatever, that would be
Okay.
great. And we'll include that in our resource if it's not already there.
I just
Thank
put in
you.
the chat the link to the Iowa Secondary Transition Learning Community post-secondary summary resource page, and on that you'll see the link for a number of different things, but the decision-making services and supports, you can click on that and get the information that Kirsten was sharing.
And there's just another thought that occurred to me. I know you have to end this session, but the University of Iowa Law Library and the State Law Library is going to be launching a People's Library in the later fall. And I have done a sort of a step-by-step, here's how you establish a guardianship, how you establish a conservatorship, and there are multiple links to resources for alternatives to guardianship and conservatorship. So maybe, Amy, I could make that available to you when it is launched. I think it's not ready to be launched quite yet, but that might be helpful too.
Absolutely. That sounds great. Thank you. Thank you. Thank you so much, Josie and Bill. This is such an important topic, and I think we need to revisit it somewhat regularly to just kind of keep moving forward with not only what needs to happen in Iowa, but how can we support all the players with having what they need to feel informed and to be able to do what they need to do. Any other questions or comments right now from folks? Thank you. Thank you, guys.
Thank you.
Thank you.
Julie Christensen. I just made you a co-host.
Hi,
Hi. So good to see you.
how is everyone on this lovely late August day?
So our next presenter is Julie Christensen, the Director of National ICIE and all things policy empress.
I know nothing of you.
So Julie's gonna talk with us a little bit and give us a federal policy update. So take it over, Julie.
So I might help you guys make up some time on your agenda because there's not a lot to share right now. I'm gonna start by just lowering everybody's expectations because Amy is always so kind when she introduces me. So August is, August recess month. So technically Congress is back home in states meeting with their constituents. There have been a few things that have been flying through. But let me just kind of give a quick sense of what is going on, which is there's a lot going on and then very little that relates to disability policy, the disability policy agenda. So I'm just going to start by saying that we are now in election season, and I cannot stress enough the importance of the upcoming midterm election. This ICIE is a nonpartisan organization. I am a registered independent. I'm an equal opportunity critic to both sides of the aisle. So this is not a political statement. This is about needing everyone at the ground level to be asking folks to get to the polls and vote for people who include disability policy as part of their agenda, regardless of what side of the aisle that we're on. We need as many folks in elected office who care about these issues, because a lot of what we have tried to accomplish over the last almost now 2 years of the Biden administration, really there's been very little success, which is frustrating because moving into the Biden administration, again, not a political comment, but there was more intentional emphasis on the disability policy agenda going into the 2022 election than we have seen. I think I said the wrong year. This is 2020, sorry. Than we've ever seen, which was huge, but I think it also left us with a lot of expectations of what that was going to translate to into, federal policy, federal agency guidance, all of those things. We have so many really strong allies in positions of significant authority within the federal government right now. And we've made very little progress over the last 2 years. So it's a stark reminder that this is the long game in terms of looking for the things that we know we want and need. So with that in mind, the fact that it is an election year does change the scope of what it can happen at the federal level. Really, at this point, Congress is focusing on some of the things they have to do. So reconciliation, appropriations, all of those things that are budget related are going to be top of mind, including continuing to make sure that we have the mechanisms we need to keep the government open. I don't think that we're going to see any problems with that piece on an election year that doesn't serve either party. But depending on the outcome of the elections, November and December could be a little tricky. So more to be seen there, and a lot that we won't know until we know the outcome of the elections and what that's going to mean in terms of leadership, both in the House and the Senate. So some of the legislation that is in progress that I know I've provided updates on before are in a little bit of limbo. So I'll go through just a couple of them in terms of updates. One being the Able Age Adjustment Act, which right now is the only piece of legislation that still continues to have momentum, and we have some sense of hope that this might cross the finish line. So keep plugging on that if you're already engaged in local, advocacy and state level advocacy, then please keep pushing on that, because that's one that does have strong bipartisan support and continued momentum. Money Follows the Person has some short-term relief in terms of extension. I know you guys have talked about that. Iowa has one of the strongest MFP programs. I think I'm a little biased, but so that is really good news, but there is continued work around trying to create a long-term permanent solution for Money Follows the Person. Those conversations continue to happen, but they really, I would say at this point, are kind of stalled until the next Congress is seated in January. I would say the same is largely true for all things Social Security reform. So I'm pretty sure I spoke at a previous ICIE meeting with some cautious optimism that we might get a few things across in terms of short-term wins on Social Security reform. There's no ability to do widespread Social Security reform right now because of just the politics of Congress rate at the moment, but there were pieces and parts, particularly marriage penalties, raising some of the asset limits. Those pieces and parts have tried and failed to be attached to different pieces of legislation. There still is interest in looking at some of that with some of the budget reconciliation, but what can be included through those avenues is based on congressional rule that is way above my brain's capacity to understand. I just trust other super smart people when they tell me we can actually make this work, or nope, it's not going to work in this piece of legislation. So when I know that it's attached to something that's actually moving, I will definitely keep you guys informed of that. Of course, Transformation to Competitive Integrated Employment Act is one that you all know is near and dear to my heart, and particular thanks to a lot of you on this call, as I'm seeing faces and names who have really engaged around this bill in its various iterations. I am sad to say that at this point, this is probably a dead bill for this Congress. We're having conversations already with the lead sponsors, both in the House and the Senate, on prepping for a revised bill to be ready to be introduced early in January. But the reality is that at least there is a possibility that on the House side, they will continue to try to move forward on this. It's a win for the House to get as many things sort of across the finish line as they can. The problem with the transformation bill is it's a no-go in the Senate until we get some strong Republicans. So I'll say to all of y'all who live in a state who have some Republican senators who actually have been historically allies, and they happen to be really high in the ranks of the Republican Party, man, would it be great if Ernst and Grassley would come forward and say, we support the disability community, we always have. This is something that should move forward. So I'll just put that out as a challenge to y'all to continue to push there, because I know you have tremendous influence with your senators, and they are allies, we know, on this issue, if not willing yet to pen that on a piece of paper. That will be huge in moving this forward. So that's legislation. In terms of other sort of just federal initiatives, I wanted to flag that Ability One, and I know we had quite a conversation about Ability One maybe 6 months ago or so, and there's been a lot of change in the program. So I'll throw that out as something that if folks would like a deeper dive than I can do today on what's happening in the Ability One program, we can schedule some time to do that. I'd be happy to do that. But the Ability One Commission did release a strategic plan this summer, and also they issued their final rule on 14C, where there is a relatively quick turnaround where all 14C certificate holders, all Ability One contract holders have to eliminate 14C entirely. Politically and from a messaging position, this is a huge deal. Logistically, I want to put this in context. There are currently only less than 700 individuals around the country earning sub-minimum wage under an Ability One contract. So I want you all to be aware of that, because as the counter argument, it is now screaming loudly around the future of sub-minimum wage. Within the Ability One program, this really is a non-issue. The Ability One program has already been moving this direction, and there are some significant supports that are going to be put towards the remaining contract holders who still operate under 14C certificates, and APSI is actually helping with some of that work. So that is good news. We are starting to engage now with SUPRA, which is the Ability One Commission of State Use Contracts, who have a lot of interest in this area. So we're starting to engage on 14C from that angle as well. So we are not giving up on this. I still will die on the hill of saying it's just a matter of time. It's not an if, it's a when. But the mechanism in which we're going to get there seems to continue to be a moving target, unfortunately. But a lot of states this year passed 14C legislation. we just had Ohio, actually, I don't think they've introduced yet. They're about to introduce legislation as well. They're a year-round legislature, so they can do that. And we're already prepping states that have had legislation in the past that didn't get across the finish line, and states that are interested in putting forward their own 14C legislation at the state level. We're just going to keep plugging there. But right now we have almost half the states have eliminated 14C on their own. And it's just a matter of time before we get the feds to fall in line. One of the things I will say about the strategic plan, and APSI has been really heavily involved in the negotiations around this behind the scenes. We're a little, well, no. Well, I'll say APSI is a little. Julie personally is kind of pissed off that the commission ultimately opted to punt on use of the language of competitive integrated employment in their strategic plan. Their reasoning for that is based on some significant pushback from some advocacy groups, including some labor unions. And that's a whole other thing that, you know, would really be a cocktail hour conversation if you really want to know what I feel about that. But regardless, where they have sort of landed is this idea of using labor terminology that we have good jobs and we have optimal jobs. The problem in the AbilityOne space continues to be ratios. So to be super clear, because we often conflate in the 14C conversation that 14C is only a wage issue, it has nothing to do with settings. So we can eliminate subminimum wage within the AbilityOne program. That does not do anything within the AbilityOne program to address settings and the ratios that right now they are obligated to maintain under Javits-Wagner-O'Day legislation, which needs to be changed by Congress in order to change that ratio. So keep an eye for those of you who are in the weeds of some of the Disability Act authorization stuff, which I really try hard not to be. So if you are one of those people, I would love to be your friend so you can keep me posted what goes on there. It really hurts my brain. But there is some effort to do some tweaking around ratios within that legislation as it moves forward. So we'll see. I think that's it. But speaking of settings, let's pivot to the HCBS final rule, which is going to be implemented, folks. It's gonna happen. I know that there are a lot of people across the country who are digging their heads in the sand like cute little ostriches. I happen to think ostriches are cute, so I have a certain amount of sympathy and empathy for the folks who are in this boat with their little tail feathers wagging, but this is going to happen. It is not going to be punted. And so supports to Medicaid funded employment providers and other service providers. This is not just an employment piece, but this is where the sheltered workshops funded under Medicaid, that piece comes in. HCBS has no bearing over AbilityOne contracts, so keep that in mind. You know, they're not all the same. Sometimes it's an AbilityOne program, sometimes it's a Medicaid funded pre-voc program. I'm speaking to the choir. I don't need to talk more about that. Other than that, I wanted to flag that we are working with the broader disability advocacy community to dig into some of the CDC revised guidance on COVID. So you may have seen that the CDC has revised some of their guidelines around quarantining and the time frame, and you know we're obviously concerned about the impact on people who have medical needs that place them at significant vulnerability in the workplace. So trying to figure out what that means and what we need to do to be pushing back and ensuring that people with disabilities who are in the workplace at historic rates, I might add, if you're keeping track of labor participation ratio data, that folks are safe as we move into whatever our new normal of post-crisis part of pandemic. We're not out of pandemic, but we're out of the crisis part. So figuring out what that means, and don't even ask me about monkeypox. I don't know. I don't have the capacity to take that on right now. The only other thing that I will throw out is that Kathy McMorris Rogers, sorry, who is leader in the House Energy and Commerce Committee, has put out a call for comments around disability policies for building opportunities for work and inclusion. It's an interesting ask coming from her and coming from her committee, because much of the work that we do is outside their jurisdiction. But the reason I want to flag it for all of you, and I will, after I'm done talking, I'll throw a link in the chat so you can take a look at that document, is that she is positioning herself pending the outcome of the midterm elections to be in a higher position of leadership within the Republican Party. And so I am really encouraging folks, regardless of whether or not the issue is within the jurisdiction of the committee to which she is currently assigned, she is someone positioned to have a lot of power. And she cares about disability issues. So the more that we can kind of get in the hands of her and her staff to prep her for thinking about what comes next in the 118th Congress in January, the better. And then the last piece I will flag is that there's a new set of federal resources on employment that have come out from a collaborative work group of federal agencies spearheaded by our friend Allison Barkoff, formerly of the disability advocacy community, but now over at the Administration on Community Living. So I'll put that link in as well, but they've done a really nice job over the last 2 years. If there's one thing that I will say has really come out of the current administration, is this cross-agency work group that has been trying really hard to think about disability policy broadly, but also employment from a cross-agency perspective. What does it mean in the Medicaid system? What does it mean in vocational rehabilitation? Where does labor and workforce development fit? Where does the education department fit? Any of you who have done state level systems change projects, which is probably all of you, because, you know, Amy and Jess kind of, you know, were a big part of the PI grant way back when, which is how I got to know their brilliance. You all know that it's that collaboration that makes it work. The federal government loves to put out grants to ask the states to do that, but they don't know how to do it themselves. And I do think there's been a lot of progress in breaking down some of those silos over the last 2 years. So I'll put a link to that as well. I think that's all I can think of, but I am happy to answer questions. And I have not looked at the chat, so.
Bill, do you want to ask Julie what you put in?
Able?
Sure. Yeah, any movement on that? A lot of folks I talk to are really, you know, concerned about that. So is there any movement on the Able Age Adjustment Act?
Yeah, so ABLE is one of the only pieces of legislation that I'm aware of that continues to have momentum. What I will say about ABLE is that it has really strong bipartisan support. There's not a lot of commentary on the Hill in opposition to. It becomes an issue of where it can be attached to get it over the finish line, because at this point in the legislative calendar and with midterm elections, there's very little happening standalone. But that's the one piece that I think particularly it's worth continued outreach on, because I think that could be a win before the end of this Congress. I will say, as an aside, that you can ignore everything I just said about legislation pending the outcome of the midterm election. So you may be hearing from me in a, you know, mass panic of, we got to activate depending on how the midterms turn out, because we have a legitimate opportunity to do some quote lame duck stuff in the last 2 months of the year. There are some races we're watching where we think the tides are going to turn, and we know that there are in particular a number of Republicans in states that are either leaving office or are likely to not be reelected, that we know have verbally committed to some of our policy priorities, but haven't been willing to put their name on it because of the politics. But the minute the midterms are over and it's clear that they're not returning, it's a window of opportunity. So more to come there.
Other questions or comments for Julie?
I think I also need to apologize for blowing you all off at the last meeting. I think that's still true, and I haven't seen you since then. So I am so sorry that I just completely did not read my calendar correctly. So it's really nice to be with you all, and thank you for inviting me back.
It is so good to see you, Julie. Thank you for the wonderful update. You always make things seem just understandable to me. I just greatly appreciate you taking the time and
Always.
just kind of helping try to unpack and even just bringing up to the top of the surface the things that maybe we should be paying attention to, because sometimes it's hard to know where should we be looking, what should we be paying attention to. And I think you're brilliant. So thank you, Julie. Thank you. Thank you.
You're only as brilliant as the people you surround yourself with. So thank you, Lucy.
Leanne Moskowitz, I just made you a co-host as well. And we are very excited to get an update from you.
Good
And
morning.
I put the materials that you shared with me in the share folder for folks as well.
Sure.
So the stuff that Leanne's going to share should be in that folder. So I'll turn it over to you, Leanne.
Absolutely. All right. Hopefully you all are seeing my screen. Seeing the right, can you see my screen? No?
Not yet.
Dun, 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 dun. Let's see. Try again. All right. Are you seeing it now?
Yep.
Okay, good. All right. So I just wanted to give you all kind of a high level overview of what's going on at Iowa Medicaid. There's been a lot. Oops, sorry. I'm trying to close my stuff here. So I'm looking at you all and not looking at my screen here. So COVID-19 CMS flexibility. So of course, the public health emergency, we have not received the 90 days note or 60 days advance notice of the PHE ending on October 16th. So we are assuming that the PHE will be extended again out till January. We continue to work on our unwind plans. We're reviewing our flexibilities that were granted during COVID. I think from an HCBS perspective, we're really looking at extending some of the flexibilities around respite while caregivers are working to keep people at home due to the direct care workforce crisis. And needing to be able to backfill some services, when service aren't otherwise available to meet that need, to have someone in the home providing that protective oversight. So with that, we'll be publishing the updates to our website as we go along. We've been trying to put stuff in the monthly newsletters, the Medicaid member newsletters, as well as the general HHS newsletters. So more to that. If you want information on that, I've provided the link there in your update. Medicaid town halls. So the Medicaid town halls are tonight. If you're interested in participating, it's a great forum with our director Matney, and it's a great opportunity to bring issues forward and to be heard. There are member and provider sessions, and so the provider sessions run from 4 to 5, and the member sessions run from 5 to 6 tonight. If you'd like to register, just click on that link in the document and go out there and register, and you'll be sent the link to participate in tonight's calls. HHS alignment. So beginning July 1st, 2022, we are now known as Iowa Health and Human Services, Iowa Medicaid. We have dropped Medicaid, or dropped Enterprise from Iowa Medicaid. And so we're in the process of rebranding. We are in the process of updating all of our materials, communications, websites with the new name, as well as the new logos. So if you happen to be trying to find something on our website, chances are maybe it's moved or it's currently disabled or something. You know, please reach out and we'll get you the information that you need if you can't find it out there. American Rescue Plan Act. So we submitted our quarterly American Rescue Plan Act spending plan and narrative to CMS for July 19th submission. Those are available on our ARPA webpage there with that direct link. We do have a mailbox for stakeholders to submit questions and comments regarding our ARPA spending plan and narrative. We are, you know, welcoming ongoing feedback for the projects. We just closed the third round of recruitment and retention payment applications last Friday. We'll be working on getting those calculated. There weren't a whole lot of applications that came in on the second application period in the third round. But that is what it is. And so we are going to be opening a fourth round for recruitment and retention grant funds that'll run from September 1st to September 22nd. We are expanding this opportunity to all of providers that fall under the broad HCBS umbrella. So we are looking at extending that opportunity to our home health agencies that provide personal care and private duty nursing, all of our 1915C waiver providers, all of the 1915I HCBS habilitation providers, our rehabilitative service providers, and that would include our ABA, behavioral health intervention services, community-based neuro rehab services, and mental health and SUD services. We're also extending this out to our targeted case management entities, as well as our PACE organizations. And so I would be looking for that IL to come out in the next week or so, announcing that application period will open on September 1st. Another thing that's different this time is that we are allowing providers to include support staff that directly or indirectly support HCBS. We've had a lot of questions about the recruitment retention grants regarding support staff. So our drivers, our clinicians, our HR staff, you know, everybody was, there were some apparently hurt feelings out there of certain staff folks being excluded. And so we are extending this out to staff that directly or indirectly also support HCBS. So your house managers, program coordinators, your, you know, employment supervisors, et cetera. And so we are excluding home office, corporate home office staff. So if you're an organization that have staff, you know, working out of the headquarters over in Omaha, those staff aren't included. Only your local staff. And we are excluding executive personnel because we all know those folks typically have alternative payment arrangements under contract with their boards. So we'll be excluding those folks as well. So stay tuned on that. The next grants that will come open will be the Health IT and Infrastructure Grant, the Employee Training and Scholarship Grant, and the Remote Monitoring Grant. And there is a lot of opportunities within these grants for providers. Let me see if I can get my file open here, and I will just kind of run through some of the high level overview of the projects, so you all can be thinking about this. We anticipate opening up that application period for those next three grants starting October 1st. We do have to, we're trying to figure out if we have to do a directed payment through the managed care organizations like we did like we are with the recruitment retention grant, or if Iowa Medicaid can make a direct payment through the MMIS to providers. And there's just some nuances that we're still trying to figure out about the directed payment process. I have learned more about the directed payment process in the last 6 months than I thought I would ever care to want to know. So we're going to meet internally tomorrow to come to a decision on whether or not we need to do a directed payment or whether we can funnel these payments directly to providers through the MMIS. So some of the things, and I'm going to share with you all a working document here, and this is an internal working document, but I want to share it with you just so you can see a run through of the eligible projects. And so this first one that I'm showing you is the health information technology. And so these are categorized into basically 5 major categories, I would say. And so the first category is projects that expand a provider's capacity to serve HCBS participants. And so it could be purchasing a vehicle to transport HCBS participants in more individualized ways. So if you're a provider who delivers transportation as part of your SE service, you might be looking at vehicles or accessible vehicles there. Vehicles modified or purchasing new or modified for use by your staff in the performance of HCBS duties. So if you have a job coach that is going from site to site, working with people throughout the day or throughout the week, then you might consider purchasing a vehicle for utilization of the staff within the organization. Purchasing of single-family homes to expand access to HCBS residential services to individuals with complex needs and those transitioning out of institutional care. Renovations to existing homes and buildings where direct services are provided. So if you, perhaps you have a day habilitation program, you want to expand capacity, you want to develop some different service areas to accommodate a need, you could do that. Again, looking at what is the benefit to the Medicaid member receiving the services and supports. We'll also be looking at purchasing of critical building systems, so upgrades for electrical, heating, ventilation, air conditioning, security, life safety, lighting, utility type of things, telecommunications. Projects that improve access to care and monitoring of the quality of care. So maybe purchasing a certified electronic health record to improve quality of care for the member, projects to comply with the federal EVV requirements. So again, technology, purchasing or upgrading, modifying your current software or hardware, and then training costs. And for each of these projects, we included basically the same criteria for purchasing, modifying, and provision of training costs. Looking at also purchasing of electronic service record technology. So if folks are still, documenting on paper or perhaps some other method that is less than efficient, they could look at purchase of electronic service documentation technology. Telehealth equipment and software to enable you to deliver services more effectively via telehealth. And again, we've got some requirements around there. It's got to comply with relative safety laws, protection of privacy, etc. And then training costs. Purchasing of services to improve your overall organizational infrastructure. So you may be looking at hiring consultants to assist with developing databases, financial management systems, your meaningful use EHR, technology-enabled services, or internal quality and monitoring projects. You may also look at purchasing of technology or other equipment for HCBS staff to support community-based service programs. And then we have one-time purchases of equipment to increase HCBS participants' independence in the community and community access. And so adaptive equipment to assist people with community access activities of daily living, perhaps a wheelchair ramp, a vehicle platform, ceiling lifts, those types of things. And again, these need to be things that aren't otherwise available through the HCBS waivers, specialized medical equipment, or the home and vehicle modification benefit. And these would be things that would benefit more than just one individual within the organization. And then other assistive technologies, so equipment, software, products used to increase or maintain functional capabilities. Other projects that meet the intent of improving, enhancing, or strengthening Iowa's HCBS infrastructure. So we wanted to allow some flexibility for things we didn't think about. And then projects that align with projects described above and that have been implemented since April 1st, 2021 are eligible for the grant funds. Providers will need to include a detailed description of the project, its intended outcomes, and provide a detailed budget to support the request of the funds. And so there'll be other instructions and guidelines around that. So that's the HIT and infrastructure grant. And then the other one with expand remote monitoring, which I think is a great opportunity to maybe build upon the lessons learned with the utilization of tech. Whoops, those are my notes, sorry. I think it's a great opportunity to maybe leverage the lessons learned with the USAID project of when we were providing job coaching through the use of remote support, utilizing the iPads or that type of technology. And so I think there's opportunity here. We do have a lot of providers that are looking at technology enabled service in order to try and close the gap with the direct care workforce. And so I think there's a lot of opportunity and probably a lot of people that are being supported today with either with long-term job coaching or perhaps individual supported employment that could really benefit from the use of technology rather than having a body there with them at all times on the job. And that could be a means of providing that ongoing support as well. And so projects for this, need to be able to expand the provider's capacity to serve participants by providing remote support services. So you could purchase consultation services to implement technology enabled services. We have in our HCBS Innovations Work Group, we've heard from two entities that do support technology enabled services, and in the up and coming HCBS Innovations Work Group on September 7th, we will hear from another Safe in Home on how they are using technology to support individuals and reduce the dependency on having a direct care staff present at all times. So purchase of smart technology, hardware or software or home automation devices to augment direct service delivery. And while this seems geared towards services in the home, I think folks need to think more broadly about different service lines, employment, pre-voc services, rehabilitation, where these technologies could perhaps be leveraged to some degree. So purchasing of smart technology, and we've kind of listed a list out there. It's not all inclusive. I'm sure there's more things out there that would be acceptable that aren't listed here. So this isn't supposed to be an all-inclusive list. Purchasing of two-way real-time communication technology that enables individuals to communicate with a remote staff. So if you're familiar with the remote monitoring model, there's a centralized monitoring station where the member has immediate access to a staff at any time when they're in the home, have a question, they push the button, go and staff pops up on the screen and they can interact in real time with the staff to address their concerns or receive guidance or what have you. And so the funds could be utilized for that. One-time purchases of supportive technology. And so very similar. Again, these are things that are not otherwise available through other dedicated funding sources like our HCBS waivers. So it could be, assistive technology like medication reminders and dispensers. I know I've heard folks have a really hard time sometimes getting that through DME or through specialized equipment. And so this may be a way to make that more accessible. Wearable technology that isn't directly related to a personal emergency response system or personal locator system. So it could be for health monitoring, that type of thing, in addition to those other uses. Health trackers, augmentative communication devices. We know that the Medicaid coverage is kind of sketchy on augmentative communication devices, computer accessibility devices, frequency modulation systems. So these are for folks that are either deaf or hard of hearing, and then optical character recognition software systems, screen readers, other types of assistive technologies, you know, and then other assistive or supportive technology recommended by professionals for an individual. And then training and technical assistance in using the assistive or supportive technology. You can also use it to purchase technology or equipment for HCBS staff to support the delivery of services. So smartphones, tablets, laptops, desktops, training and technical assistance in using that technology. And then other projects that meet the intent of improving, enhancing, or strengthening our infrastructure. And then, of course, for this one also, we know we have some providers who have already implemented some technology-enabled solutions within their organization. And so we wanted to also recognize that and give them the opportunity to receive some funds to support the costs that they've already expended towards those projects. So again, those are some of the projects that are listed under that. For the remote monitoring grant then, or for the training and scholarship grant, I think people, you know, really need to think about trainings that are coming up. We want to get our staff, you know, certified as an employment specialist. We need training in job coaching. We need, we want to bring in a consultant to help us decide how we can, you know, develop a training program within our organization. And so I think there's a lot of opportunity there, and it's really broad. It could be used to pay for CEUs. You could use that as a recruitment and retention tool for your staff, you know, and to just really move the goals of the organization forward when it comes to training and development. So more to come on those. LMS, we're currently looking at a learning management system. We've looked at a couple of systems that are utilized in other states, and had a small group of stakeholders come together to talk about what's important to them and what role they'd like to play in reviewing those types, the type of LMS that the state will eventually choose. And so right now we're just reviewing options and hope to get some demonstrations scheduled in the near future. We're also working on a direct service board on hiring resource. Again, this will be a place where individuals who are seeking direct care workers can go and post their need for workers. This will also be where direct care workers could go and post their availability and make a match with individuals seeking direct care. We know that the direct care workforce crisis has really exacerbated the ability of individuals, especially those who are self-directing, to find qualified and available staff. And this is one way that we think can assist in matching up folks to matching caregivers to the individuals who need those services and support. So work group updates. Oh, let me pause. Take a breath. Are there any questions? Sometimes I forget to stop and ask if there's any questions.
Folks are welcome to just unmute and ask Leanne directly if you don't have to type it in the chat. This is great information, Leanne. It's fabulous.
Great, great. All right. Hearing none, I'll continue. So then looking at the HCBS Innovations work group, this work group meets just about monthly. We didn't meet in August because I needed to take a breath and regroup with everything going on. But we will be meeting again on September 7th. Dawn Shirley with Safe and Home will present on their technology-enabled services. So as I said earlier, another technology-enabled service model that is really interesting and really, I think, holds a lot of promise for helping to fill some of the gap created by the direct care workforce crisis. I just want to reiterate and say every time I have a chance to talk about it, it is not intended to replace direct care staff. It is intended to maximize the direct care staff that we have available in our systems. And technology enabled services and supports may not be for everyone. And providers who are wanting to implement a technology enabled model will need to develop a way to assess the member's ability to be safely supported through technology. You know, if you have somebody who needs a lot of staff intervention, either for cognitive or behavioral reasons, a technology supported model may not be the way to meet that person's needs. And so I think it'll be an interdisciplinary team and the member getting together and reviewing what the needs are, what supports, what the backup plan is in the event of emergencies, and again, make a determination on whether or not a person could be safely supported in this way. We know we have people that have staff there 24/7 that really don't need to be there 24/7. They're there incidentally in case something happens. And if we can find a way to maximize the staff that are available in the system, we may be able to meet some unmet need that exists in the system today. We know we have a lot of people that are on waiting lists with providers for services, sometimes 6 or 12 months. Folks are waiting for services. We have a large number of HCBS people that have gone, you know, sometimes 12 months without services because they are waiting for the provider to have capacity to support them in their community. And again, we've got to keep trying to find ways to maximize what we do have in the system, because we know Iowa population isn't really growing. We're pretty stagnant and expected to lose population in the future. So ignore this out-of-state placements. That was from a prior report. So you can see that I'm, you know, copying and pasting stuff from another report. Legislative reports, here's your reports here. You can find those. HCBS policy changes. And so we've had a lot of changes this summer. Things are coming up. We just implemented the eligibility and home-based habilitation criteria for the HAB program starting July 1st. Folks will have the comprehensive assessment and social history completed. And in addition, they will have the locus or the Cal locus scored to determine eligibility, as well as if they're a person who requires home-based habilitation services, that locus or Cal locus will be used to determine which tier of home-based HAB services they will receive. And so there were training that we did in June for that, and that all of those training materials are available online on the Provider Tools and Trainings webpage. 5-year rule review, all of our technical corrections have been made and they are with the rules editor. And it seems like they're rolling out a few chapters each month during the administrative rules committee. And so you'll see those come up probably for the next 6 months or so as they try to work their way through all of the HHS chapters. HD and PD waiver renewals. We just submitted our response to comments to CMS this week, and so we'll wait for their feedback. HCBS waiver manual update. So we are making some additional updates to the manual and putting in some additional CCO guidance around that. I probably should add here the HCBS habilitation provider manual updates are also in process to reflect the changes that were approved by CMS in June. Service documentation training. So this is a good one. The public notice closed on August 19th. We did receive quite a few comments of support for the changes. We also received some comments from providers who are perhaps confused that we are implementing new requirements rather than just clarifying the old requirements. And so we'll be addressing those through our responses. We also have training that is scheduled on the service documentation and service monitoring requirements. So what do we expect to see in the service record? And then what do we expect our case managers and care coordinators to do in cooperation with our providers in monitoring the delivery of HCBS? And so that training will be September 20th and September 21st. We will be offering 2 sessions. You only need to choose to attend 1 session. They'll be the same materials, and we will also record it and get that posted for everyone who was unable to attend either of those sessions. Cost report rules. So the cost report rules are with the editors right now and should go to the bulletin, I would assume, either the first or second session in September. And then the HCBS rate increase. So as of July 1st, all HCBS rates were increased by 4.25% over the rate in effect as of June 30th, 2022. That would include our HCBS pre-vocational and supported employment services. And that, that fee schedule has been updated and posted out online. So training opportunities, I just talked a little bit about this. We do have our community-based training and technical assistance. I think Courtney's on. This is the link to go out to the website to look at prior trainings as well as up and coming trainings and register to participate. We do have the behavior intervention planning training coming up on the 31st. From 12 to 1. And then here's the service documentation that I talked about. And then in October, we have implementing person-centered service plans. And so that date hasn't quite been nailed down, I don't think, but there'll be an informational letter that will come out about that. We do have an informational letter in flight right now that announces the service documentation and monitoring training and provides the links for registration for participation in those trainings. Communication coming out of the department. There's been a lot, so you can click on this direct link there and it'll take you right to that informational letter. The third ARPA, the third application period for ARPA just closed. So these are kind of the ILs that have been out recently. IMPA member and habilitation waiver eligibility information updates. So providers now have the ability to go into IMPA, logging into IMPA and putting in a member state ID to determine what their waiver eligibility and HCBS habilitation eligibility is. So, you're serving someone who's eligible rather than finding out later they're not. Also, we amended the terms and conditions, IL back to June or May, talking about the changes, and then of course the billing updates. And the billing updates talk about recording that location of service, etc. And then we've got employment data to share with you. Before I share the employment data, are there any questions for me so far? I know it's a lot to take in. I kind of give you information by fire hose, right? All right, let's share the employment. So with our employment documentation, is that big enough for you all? I can make it a little bigger. How's that? So if we start with BI, we can see we had an increase in April of 2022. And just to remind you all, starting in January, we started to collect this 4 times a year instead of 2 times a year. And so we are now collecting data in January, April, July, and October. And so the July's data will be available in October. And the October data will be available in January. And there's a little bit of lag on the reporting. But we can see that we increased the number of people on the BI waiver that are competitively employed. We can also see here that we did increase the number of folks who were participating in individualized supported employment. So we are making progress. We're moving the needle a little bit for our BI waiver folks. Wages and earnings, the hourly wage stayed about the same. Under long-term job coaching, we also saw an increase there over the prior months. Wages, I think wages were driven down, the hours were driven down a little bit by the increase in participation, which had the same impact on the wages and the earnings. So we saw a slight, drop in wages and earnings, probably because of the increase in the volume of folks getting the service. We also saw an increase in small group supported employment. Hours just dropped slightly. Again, that's probably a reflection of the number of members being increased. And then our average earnings, the wages for that, and then pre-voc, we only had 3 folks on the BI waiver. The star here means that only one MCO reported numbers, which means the other MCO didn't have anyone participating in small group SE. So these numbers come from one MCO, and you can see it was the same way for the prior 2 quarters as well. Only one MCO had individuals enrolled in pre-voc that were on the BI waiver. Career exploration, we have had no participation in career exploration on the BI waiver for the last 4 reporting periods. And so I'm hoping those folks are getting those services and supports under individual supported employment, but I suspect they're not. Just based on the numbers here, you can see, we don't have a whole lot of participation on that level either. So a lot of work to do on addressing employment for the BI population. And then when we get to habilitation, you can see again, there was just a slight drop from 21 to 20% during the month of April. Individuals receiving supported employment or competitive integrated employment, individual employment increased significantly, which was great. And I was really pleased to see that. Again, we know that employment is a big part of recovery for folks who are participating in the habilitation program. We can also see average hours increased, the wages, overall average wage or earnings went up, and average wage went up. HAB long-term job coaching, we also saw an increase, which makes sense. Folks usually come into long-term job coaching after participation in the individual supported employment. Again, we saw not a huge change in wages or hours, which I think is good because it shows stability even though the population increased. We also have the small group supported employment, again, stayed consistent from the prior quarter with 100 participants. We saw hours go up slightly, earnings go up slightly, and wages go up slightly. And then for pre-voc, we still have a high number of HAB folks participating in pre-voc. So you can see here that the average earnings stayed relatively consistent, and we saw a small increase in wages earned for that period. And then career exploration, we didn't have any members participate during the last reporting period. And then individual placement and support, we only had one MCO reporting Medicaid funded IPSSE. That doesn't mean folks aren't getting IPSSE. They may be getting it funded through the region or funded through VR, but these are Medicaid funded participants. So I was glad to see that we're starting to get some Medicaid covered IPSSE services going. Then here, and we saw a nice little bump in wage up to $11.25, not a livable wage, but a bump. Now we're seeing for the ID waiver, you can see that again, number of members competitively employed increased over the prior quarter, so that's good. We saw an percentage increase from 21% to 25%, so that was a good progress there made during the last reporting period. For the individual supported employment, again, we saw a huge jump in the number of people participating in ICIE, which is great. I was pleased to see that, just given all of the concerns we have around not having available job coaches or employment specialists. And you can see that the wages, the hours, 15 hours a week, our average earnings and average wages for the ID waiver folks. And then for LTC or the long-term job coaching, again, we saw another bump, which is great. Hours just stayed relatively consistent. Wages, again, not a huge, or earnings, not a huge decline, relatively consistent. Earnings or hourly wage, excuse me. I think the differences are just in the volume of people being served. And then we saw small group SC. This is what concerns me here, is these folks are supposed to be in competitive integrated employment and they're earning sub-minimum wages. I'm assuming that these providers that are supporting these people have 14C certificates. I was out looking yesterday and we still have 13 agencies that have 14C certificates. And I think of what is probably most concerning is the majority of those agencies are renewing their 14C certificates. So they intend to continue to pay sub-minimum wages for those folks who are performing services under contract while they're learning in pre-voc. So I'd like to see us move the needle on this a little bit. And then the career exploration, again, only one MCO was reporting these numbers for this quarter for the ID waiver. We only had 6 participants. These folks work about 12 hours a week and earn about $3.42 an hour. So we know, again, they're likely working under contract in the pre-vocational center, being paid, per widget or being paid based on their performance and their relative standards to a person without a disability under that 14C certificate. So again, I'd like to see us move the needle on these wages. I just, I think we'll continue to see this as long as 14C certificates continue to exist. So that's our employment data. Overall, I think we had a good show this quarter for April. Saw some improvements, and I think we're moving in the right direction. Any questions for me on that?
Thank you so much, Leanne.
Absolutely.
This is really great information to have, and it really helps to have more sort of data that we're able to take a look at, and we'll continue to hopefully build on that so we can kind of assess how we're doing in areas and what's working and where there might be opportunity to continue to build, like you had pointed out. So thank you so much, Leanne.
Absolutely.
I know that we are kind of pushing up against our ending time. So I'm gonna share a couple of things real quick with you. In our share folder, you will see the DD Council sort of state updates. So there's one piece of information that's not linked yet because it hasn't been posted, but we'll add that when it does get posted. There's a number of opportunities of different things that they're sponsoring. They currently have a job posted for the council for the public policy manager. So I encourage folks who might be interested to take a look at that or share that with folks. Bill had accepted a position, so he'll be transitioning into a different position outside of the council so that his position is available. They have a new website. Their Make Your Mark conference is coming up, and there's still opportunity. They have some grants. And just like Julie had mentioned, I really want to reinforce the importance of it being an election year. And the council has a lot of amazing resources to help you understand who the candidates are, how they align on different issues, and then how you might be able to engage with those candidates. Tomorrow is their Capitol chat. You can see here, there's a link on how to sign up. If you haven't participated in those, they're fabulous. And they also post recordings for those. I know we need to do a quick APSI update too, and I was trying to, sorry. Here we go. Because I know we're running out of time, I'm just going to do a couple quick plugs for APSI and we'll let them add things, but they have a conference coming up and it looks amazing. So September 28th and 29th, there's a pre-conference with the amazing Judy Worth. And there's an opportunity right now to also submit for nominations for the different awards that folks can be awarded and recognized at the APSI conference. So they're still taking nominations right now. And we can put the information in the share folder on that as well. I'm gonna just put the slide up again of our next coalition meeting dates, because I think not everybody was on when this was up earlier. So we have our coalition meeting dates for 2023. We're hoping to meet in person. They kind of vary each month that we have them, from being the 3rd or the 4th Thursday based on room availability at Voc Rehab. So I'm going to leave that up, and then I'm just going to go ahead and ask APSI and other, we'll do APSI first and then other partner updates, but I wanted to get those out in front of folks before people have to kind of drop off as our time is running to a close. So APSI, I don't know if Nicole's on or if somebody else from APSI wants to give an update.
This is Misty. I think there's a few of us from APSI on the call. It looks like Kari just hopped off, but she included a link to the information for the upcoming conference and training. So check out the link, and we hope that everybody would join us. And the cutoff too for getting an awesome room rate for that conference is coming up, like September 7th. So if you want a good deal on your room and want to come join us, we're going to have some great speakers and sessions, breakout sessions. Judy will be doing the pre-conference, Judy Worth, and it's a can't miss. That's about it though.
Thanks, Misty. Other partner announcements, anybody want to share? All right, well, I can't wait to see you guys in person, hopefully next year. I think the 2.5 hours has always been a challenge to, one, be able to really engage at the level we'd like with all of you, to be able to really just have conversations and allow the time and the space for people to interact around all the different things that we try to kind of talk about. And so my hope is that we're going to have in-person meetings next year. We have a virtual meeting for November of this year. But I apologize that we run always over and we never have enough time for a whole lot of discussion in these virtual meetings. But next year, I'm believing in that. So any other comments or questions that folks have? I want to tell Heather Carey how incredibly I'm excited for her from moving from Denison High School to the AAA and being a secondary transition.
Everybody, I was.
We are delighted, Heather, and can't wait to continue to partner with you in your new role.
Well, I'm very excited because now I don't have to just share with one school. I get to share with not only the schools that I'm in, but Amy, I get to be on the transition team at the AEA. Yay. So I get to take this information, and Amy and Jess, you know my love that I've been on this and how much I have fought to be a part of this, and I had to fight with my administration to be a part of this. I don't have to fight. This is a priority now with my job. And so they put me on the transition team right away. So
just so happy about that, Heather. Thank you.
So I'm very excited.
All right, well, I would just want to tell everybody, thank you so, so much for joining us today. Great information, great presentations. I look forward to seeing you in November. We will get the link to the recording and all the materials emailed out to everybody. And also it's in the folder. So please don't hesitate to reach out if you have any questions or comments or recommendations for things that you would like to see on the November agenda, or even in planning for 2023. Also, please note that Jessica Crejo has a new email address. And so if you get, sometimes the Google is not friendly. And so she had some problems with her email. So you might get a message back if you use the old one that she doesn't have it, but she has a new one. We will also put that in as just a reminder in some additional emails that are coming out for folks. So anyway, everybody have a fabulous day. Thank you very much. It's great being with you today.
Bye all.